Moving on, the big question. If you want to know the phone number of your neighbor, can you file an RTI? No, you can't. You can only get information from public authorities. Now, under section 2 subsection H of the RTI Act, we define who is a public authority. So, just like under the Constitution, when it came to the matters of fundamental rights, we had to define through Article 12 what is a state. Similarly, here as well, we have to define from whom can we request information, from whom can we access information. So, all constitutional bodies, we can file requests and get information. All statutory bodies. What is a statutory body? Statute means law. They are synonyms. So if you want to impress someone, use the word statute or else use the word law. So all statutory bodies meaning all legal bodies, all bodies created by an act of legislature, whether parliament or the state legislatures. Then bodies owned, controlled or substantially financed by the government, including state-funded NGOs. In fact, in 2019, the month of September, in the DAV College Trust case, Supreme Court has said that all NGOs which are substantially financed are also subject to RTI. So, if there is any NGO which receives state funds from the government, that is also open to RTI. So, all these bodies come under the ambit of RTI. Now, what is the process? First things first, you have to file a request. A request for information in electronic form or send an application in either English or Hindi or the official language of the area. Plus, you have to give the requisite fees. Normally, for the Central Information Commission, the fees is 10 rupees. And for BPL category people, you don't need to pay a single amount to get the information. So you have to submit this. And most important, Section 6 subsection 2 says that you do not need to give any reason as to why you want the information. There is absolutely no need, no pressure on you to disclose the reasons for seeking information. Why do you want that information? What will you use it for? Is totally up to you. You are not and you cannot be forced into providing reasons for requesting the information. Then, coming to the website. The website for RTI is rtionline.gov.in. So you can log into this website, and there is also an option for you not to register. User registration is not mandatory, and then you'll be asked to fill up various aspects, information, which ministry do you want to seek the information from, which department, your name, your gender, your address, etc. And you can never be forced into providing any kind of ID proof. Yes, you will have to fill in your address because the information will be sent to you by post. So in that case, the concerned department would need your address. But beyond that, you can't be forced into submitting an ID proof to identify yourself. There is no need at all. Right? So this is how you will fill up the information. And then below this, if you scroll down further, you will find out there's a column to write in your request as to what information you require. Plus, you also have the option to upload any relevant concerned document that you wish to upload. Now, what is the time limit? Time limit for providing information is 30 days. But if the information you are seeking relates to matters of life or liberty, then such an information needs to be provided within 48 hours only. And there was an order of the Central Information Commission on the 6th of May 2021 to further clarify on what exactly do you mean by the life and liberty aspect. So the CIC said that any pandemic related information, for example, could be considered to be a matter of life and liberty, and that would require the concerned official, the concerned department to provide you with information within 48 hours or 2 working days. This is nothing new. In fact, around 5 years back, on the 22nd of July 2016, the CIC had said the same thing. They had said that in case there is any pandemic of any kind, then information with respect to that pandemic would be something that would be covered under 48 hours. So that's the concept of 48 hours. Now, this period of 30 days can be further extended by 5 days. So it can be extended to 30 plus 5 working days. How and in what cases? Now see, let's talk about Ministry of Finance. Ministry of Finance is a big ministry. It's a huge ministry. Ministry of Finance covers 6 different departments, ranging from Department of Expenditure, Revenue, Department of Public Enterprises, so on and so forth. Now, all these departments have further divisions. In every division, you will have some kind of PIO or a Public Information Officer. It is a task of this PIO to furnish information. Now, if the department takes care of large number of activities, it may be difficult for the PIO to give you all the information. So, in certain departments, in fact, in most departments, what has happened is they have also created a post of APIO, an assistant PIO. So, in these departments, when the request has been sent to the APIO, right, in a department where you have an APIO who is an assistant who is helping the PIO, in all those situations, 5 extra days are given, considering the fact that the department's task is huge, it's large, it covers a lot of areas, so it may take slightly more time to provide with the information. Now, coming to the rights that are conferred on the citizens. What rights have been conferred on us with regards to the RTI Act? First thing first, choosing a medium of request. Whether we want to send it via post or we want to apply for the request online is up to us. Secondly, choosing the language, English, Hindi or the official language. Number 3, we are not required to give any reasons as to why we want that information. And finally, the most important, we will also be provided assistance in accessing records. And the fees has also been waived for the BPL category population. So when it comes to the people who are below poverty line, they are not required to pay any fees. So all these are the rights that have been conferred on us. Apart from it, whenever the PIO rejects information, you have the right to know the reasons for such a rejection of information. On what ground has the information been denied to you? The PIO will have to mention it. Then, if you are not satisfied, or if there is a delay in providing the information, or the information has never come to you, you may always choose to complain to the CIC or the SIC. We'll see these people shortly. These are two offices at the central level and the state level called the Central Information Commission and the State Information Commission. Now, coming to the obligation of public authorities, we have certain rights, whereas the public authorities have certain obligations towards us. Now, what does the right say? What does the Act say? The Act says that all public authorities will have to maintain their records, catalog them properly, index them properly in a form and manner which will facilitate, which will promote right to information. And more importantly, all the authorities are also required to computerize the records within a reasonable time. So this is also something that is expected of the public authorities. Even though there is a sense of vagueness here, because in what time should the public authorities digitize, computerize their records has not been made clear. So we find that in lot of state governments, under lot of these governments, lot of records are yet to be digitized. And if records are not computerized, it becomes slightly challenging for even the concerned authorities to provide you with information in a time-bound manner. So, computerizing records is in fact going to help the public authorities themselves in providing information in a timely manner. Then, the Act also says that within 120 days of the enactment of this Act, meaning when this law was passed in 2005, within 4 months of passage of this law, 16 different types of informations had to be disclosed to public on its own. Suo motu disclosure. Suo motu means, suo motu or suo motu is the same thing. Suo motu or suo motu means on its own motion. So, 16 different kinds of information. Information like directory of officers. What are the functions performed by them? What are the categories of documents held by them? Particulars of the organization, the rules, the regulations, the manuals, the records held by them. Monthly remuneration received by the officials, their phone numbers, their email IDs. 16 different kinds of information have to be uploaded on the website or provided by the organization on its own, so that people do not and are not forced to file requests for such basic information. So that's also an obligation on the public authorities. Then other obligations include providing as much information on its own to the public through various means. For example, PIB is such a means. The Press Information Bureau is how the government keeps on updating people with whatever steps they are taking, whatever new changes are being made, whether it's in administration or governance or some other field. So the very interesting aspect of RTI would be providing information on your own. Now, take an example. Why do we file a request for information? If the information was available to us, we would never have filed a request. We would never file a request for knowing who is the Prime Minister. No, because we know it. It's there on public domain. Similarly, this RTI could be very effective as a tool and rather would be used less if the authorities start providing information on their own of all kinds. It is because the authorities do not provide information on their own is what forces people into filing a request for information. Then within 100 days, over 3 months again of the passage of the law, every department will have to designate somebody called a PIO, the Public Information Officer. So in every department, you have one PIO, right? And then if the department is huge, you may also create an APIO. That's up to you, but mandatory to create a post of PIO. Now, this PIO is not somebody who comes from outside the organization. There is no separate examination for PIOs. It's not a post which is created separately. Basically, people working in the same organization, same department, who are contributing to other areas, one of them is chosen and is given the additional responsibility of being the PIO. Meaning, all the requests that come in that department for information are directed to this PIO. So this is a person who works in the same department, has been working in the same department, has been given the additional task of providing information. That's all that this particular PIO does, providing information. Now, most important is this fact. Let's say you want some information on corruption and you file a request, let's say, to CBI. And you feel, okay, CBI is a body investigating agency. Maybe CBI is under the Ministry of Home Affairs. So you file a request to the Ministry of Home Affairs that I want some information on some allegation of corruption with respect to some CBI official. But CBI is not under Ministry of Home Affairs. CBI is an attached office under the Department of Personnel and Training, which is under the Ministry of Personnel, Pensions and Public Grievances. But you did not know this. You have filed this request with Ministry of Home Affairs. What do you do now? In this situation, who is now responsible to transfer this wrongly filed request? Transferring the request to the right department. Whose responsibility is it? It is the responsibility of the Ministry of Home Affairs. So, if any PIO gets any request for information which does not pertain to his or her department, it is the responsibility of that PIO to transfer that misdirected request to the appropriate department within 5 days of the receipt of the application. Meaning, in case you have filed a request with the wrong department, 30 days plus extra 5 days time would be given to the concerned people. Now, what has been said by Supreme Court with respect to this transfer of requests? It has been found that this transferring of misdirected applications is being constantly misused by various public authorities. How? In the Girish Mittal case of 2014 or even the Rakesh Kumar Gupta case of 2021, it was found, and Supreme Court has mentioned very clearly that you are not some post office. Your task as a PIO is not merely to transfer information or transfer the request to some other department. No, you have to ensure that the information is provided. And you know how these things play out? I'm sure you're aware of something called the Prime Minister's Gram Sadak Yojana under the Ministry of Rural Development. Now, as per the website, the information available in digital format are things like tendering process, allotment of work, detailed project report. This detailed project report simply contains information on to whom the tender has been given, what was a reason for giving a tender, what quality of material was used by the person, all such information. That is what is there in the detailed project report. And when the government says we want to construct a road and they give out tenders, all the people who are interested submit a DPR. Based on that, some bureaucrat will allow or grant the tender to a certain party. Now, this case is of June 2021. What happened was one Mushtaq Ahmad Loni of the Badgam district in Jammu and Kashmir. He sought a copy of this DPR, about 9 kilometers of the Pradhan Mantri Gram Sadak Yojana project, because within 6 months of the construction, the road broke down. So he filed a request, the RTI, to the Ministry of Rural Development. After 7 days, that particular request was transferred to the NRIDA. NRIDA after 5 days transferred it to the Pradhan Mantri Gram Sadak Yojana, Kashmir, the chief engineer who was the caretaker of the PMGSY in Jammu and Kashmir. The chief engineer now transferred the request to the executive engineer. The executive engineer, after 5 days, sent a letter to the Department of Food, Civil Supplies and Consumer Affairs for verification of the BPL credentials of the applicant, because the applicant was a BPL category applicant and he had not paid any fees. So you see how this is being misused. You are simply transferring the request from one department to the other department without taking any effort into providing information. That is why in these two cases, Supreme Court has had to come down heavily eventually, and they have had to mention a statement that you are not a post office. Don't keep on transferring these requests from one department to the other. Your task is also to ensure that eventually the information is provided to the concerned applicant. So this has been and is slightly prone to misuse. So these are all the obligations of the public authorities when it comes to supplying information. Now, coming to the complaint. So before we move on to the complaint, let's now see what is the procedure. Step 1. You file a request for information to some PIO. If everything goes down well, the PIO would submit you with information. If you are not happy with the information, or if the information is delayed, or if the PIO rejects your application or does not provide you with the information and gives no reasons, you can then file a complaint. Complaint within 30 days. So firstly, 30 days are given to the PIO ideally, and then within 30 days of the failure of the PIO to provide you information, you can again file a complaint. Complaint to a senior in the same department as that of the PIO. So some senior in that same department will be given this tag of FAA, the first appellate authority, the first person to whom you appeal against the denial of information by the PIO. Now, moving on, if this senior also does not give you information, what do you do? In this situation, you can now go and file a complaint to Information Commission. This is that independent body which we had talked about under the sound RTI regime. An independent body where you can complain, where you can appeal against the information not being provided or being rejected by the concerned PIO. So, if the information that you seek relates to some state government department, you will complain to the SIC, the State Information Commission. Every state has its own SIC. If the information relates to central government, you will go to CIC or the Central Information Commission. So in this case, center, and in this case, the state. So from where do you seek information is the place where you are going to complain. So if your information relates to state government, you complain to SIC. If it relates to central government, you complain to CIC. Now, suppose you are not satisfied with the response of the CIC or the SIC. Where do you go to? In both these cases, you will go to the High Court and later on obviously to the Supreme Court. But don't ever think that you can go from SIC to CIC. No, there is no appeal from the State Information Commission to the CIC. CIC takes care of central government. SICs take care of the respective state governments. There is no appeal. Like from High Court to Supreme Court, there is no similar kind of appeal from SIC to CIC. Both of them take care of different areas. So whether the SIC has denied you information or the CIC has denied you information, you will go and appeal in the High Court only, in both the cases. Now, coming to the issue of CIC, SIC, as far as these two bodies are concerned, why would they deny the information? They will not deny it per se, but they may uphold the denial of information by the concerned PIO. The PIO may give reasons to the CIC saying, sir, these are the reasons, this is the ground on which we are denying information, and this is the reason why we can't give information. And if the CIC says, okay, fair enough, the reason seems to be sound, logical, in that case, the CIC upholds the decision taken by the PIO, and you, being the aggrieved party, you now go to the High Court or the Supreme Court to challenge this order of the CIC. So that is how the complaint system works. This is the entire chain of events. Now, it's also a good time to understand about the CIC. A very, very important, in fact, the entire burden of providing information and ensuring that this RTI is successful lies on the shoulder of the CIC and the SICs. So, CIC, the Central Information Commission. Now, what is the composition of the CIC? The CIC consists of one chief, known as the CIC, the Chief Information Commissioner, and not more than 10 other information commissioners. So, we have and we can have a maximum of 10 plus 1 people, and the CIC and the post, the office of CIC is mentioned under Section 12 of the RTI Act, Chapter 3. Now, just let us look at all the current ICs and the CIC that we have. So, this is Shri YK Sinha, Yashwardhan Kumar Sinha. He is the current CIC. He is basically a retired IFS officer from 1981 batch. We have Dr. Amita Pandave, Shri Suresh Chandra, Shri Neeraj Kumar Gupta, Vanjanayan Sarna. We also have people like Uday Mahurkar. Uday Mahurkar is a journalist. Amita Pandave, she was a former member of the PPSC, Punjab Public Service Commission. But primarily, the information commissions are dominated by retired IS officers. In fact, of the 122 chiefs that the various NGOs had information of, whether in the states or the center, 85% of them were government employees, of which more than 60% were IS officers. So primarily you will find that IS officers are the ones who dominate the information commission. Like in this case, Suresh Chandra, he is a retired IS officer. Neeraj Kumar Gupta, he is a retired IS officer. Hiralal Samaria, he is a retired IS officer. So again, you have plenty of scope once you retire to get to other posts as well. Interestingly, Mrs. Saroj Punhani, she is a former deputy CAG and a retired IAAS officer. Anyway, moving on. Now coming to the appointment. As far as the appointment is concerned, it is done by the president, but on the recommendation of the Prime Minister, who shall be the chairperson of the committee, the leader of opposition in the Lok Sabha, and if there is no leader of opposition in the Lok Sabha, then that person becomes a part of the committee who belongs to that party which has the highest number of seats in the opposition. say as of now, let's say Congress has 52 people, 52 MPs in the Lok Sabha, and Congress is the largest opposition party. Even though there is no LOP right now in the Lok Sabha, because to have this tag, the status of a leader of opposition, you also need to have at least 10% MPs in the House. Out of 543 MPs in the Lok Sabha as of now, 55 MPs at least should be there with the opposition party to claim this tag, this status. So, Congress falls short. So, under the Mavlankar rule, Congress may not be eligible for a leader of opposition. But when it comes to appointing a member of a CIC or the chief of the CIC, then since Congress is the party which has the highest number of seats in the opposition, this party sends a person, their leader, to this group. So Adhir Ranjan Chaudhary has been sent for such situations. Now this is about the appointment. Now coming to the qualifications. What are the qualifications? As far as the qualifications are concerned, the CICs and ICs shall be persons of eminence in public life with wide knowledge and experience in law, science and technology, social service, management, journalism, mass media, administration, governance. And they should not be an MP or an MLA. They should not hold any other office of profit, or they should not be connected with any political party, or they should not be carrying on any business or pursuing any profession. So, this eminence is what is required in public life, and you should have wide knowledge and experience in matters of law, in matters of science and technology, social service, management, journalism, mass media, administration, and governance. So, this is the qualification for being eligible to be appointed as a member of the CIC, that is either an IC or the Chief Information Commissioner. Now, in 2013, there was a Namit Sharma case. In the Namit Sharma case, Supreme Court said that you have to give reasons to showcase eminence of the person. Why do you think the person is eminent? So it is not a very vague idea of eminence. You have to give reasons as to why you're appointing the person. Why do you think the person you've appointed is of eminence? Reasons have to be recorded in writing. Okay. Now, after the qualification, the conditions of service. Now, coming to conditions of service, originally, the Act provided for a fixed tenure of 5 years and the retirement age of 65 years. So, under the Act, originally, 5 years was the tenure, which has now been reduced to 3 years. And now, through the RTI Amendment Act 2019, the government will decide what will be the tenure of the person. So, through the RTI Amendment Act, the conditions of service will now be determined by the government through an order, an executive order, which also means that the salary of the CIC and the ICs and the people from the State Information Commission, all that will be determined by the central government. So earlier, the salary of the CIC was same as the election commissioners, but now the salary of CIC is 2.5 lakhs, even though the amount is the same. But now this can be changed, because earlier the CIC and the ICs used to get the same salary as the election commissioners, which cannot be changed, right? But now they get a salary of 2.5 lakhs, which can be modified by the government. And the members of the IC, they get a salary of 2.25 lakhs. So this is a modification that has been done by the government. Now coming to the removal of this person. How is a person removed? The grounds are simple: misbehavior, incapacity. But the procedure, the manner is slightly different. If and on the receipt of any complaint, if the president receives a complaint against any member of the CIC, he or she will direct the complaint to the Supreme Court. Supreme Court will conduct an inquiry, and after conducting an inquiry, if the Supreme Court finds out that yes, the complaint is genuine, the allegations are true, then will advise the president to remove the person, and the president will then remove the concerned member of the CIC. So this is how the removal of the members of CIC takes place. Coming to the State Information Commissions, their provisions are analogous, similar to that of the CIC. Herein, the president appoints the CIC members. In case of SIC, the governor appoints the members. The committee consists of these three people: the Prime Minister, the LOP of Lok Sabha, and a cabinet minister nominated by the Prime Minister. In case of SIC, the committee consists of the Chief Minister, one cabinet minister nominated by the CM, and the leader of opposition in the Legislative Assembly. So we have the CIC, the chief of the Central Information Commission. Here we have the state CIC, the state chief of the Information Commission. And then the ICs and the state ICs. When it comes to removal, at the central level, the president removes. At the state level, the governor removes after the inquiry is conducted by the concerned High Court. So we have analogous provisions when it comes to the SIC with respect to CIC. Now coming to the amendment passed by the government in 2019, the RTI Amendment Act of 2019. Now what the government said was that we have to modify the conditions of service of the CIC and the SICs. Why? Because as of now, the CICs enjoy the same conditions of service as that of the Election Commission. But the government said that the mandate of the Election Commission is different from that of the CIC. Election Commission is a constitutional body. Plus, the government also said that the CIC has been given the same status, same salary as a Supreme Court judge. But the judgments, the orders of CIC can be challenged in High Court. This is an anomaly of sorts. If you are receiving the same salary as a Supreme Court judge, how can your orders be challenged in the High Court? This means that there is some anomaly. We have to rectify it. So, the status and the terms and conditions of service, they have to be rationalized accordingly, is and was the argument given by the government. In pursuance of this argument, Section 13 and 16 were modified, and the terms and conditions, the service, the tenure of the CIC and the SICs were made subject to the control of the union government. Now, interestingly, if we go back, say 15, 16 years back, when this bill was being framed, when the bill was being framed, it was sent, and normally this is what happens, the bills are sent to the departmental standing committees when they are being framed. In this case also, the bill was sent to a departmental standing committee, a parliamentary committee on personnel, public grievances and pensions. Now that committee had members from BJP, including the President of India, Ramnath Kovind, along with people like Balwant Apte and Ram Jethmalani. This committee found that since the role of CIC, the post is extremely important, even though we have not made it a constitutional body. The role, the post is so important that we have to make the service conditions equivalent to that of a constitutional body like Election Commission. So, 16 years back, the same president was in agreement with the idea that whether the order of CIC can be challenged in High Court or not is a secondary matter. Since the role is very important, the salaries, the terms of conditions of service should be independent and should be equivalent to a constitutional office. But interestingly, when the bill must have come to the president for his assent, he had possibly forgotten all about his stand 15 years back. In 2004, the stand he took on the same matter, and he gave his assent to the bill. Anyway, so the problem here is that when an independent body's terms and conditions of service are made subject to the order of the government, this questions, challenges the independence of the body. Or else, why would we have various constitutional posts where the salaries would be charge expenditure? Why do we have this concept of charge expenditure? There are certain debits, certain money which is appropriated from CFI, which is taken out, withdrawn from CFI, which will not be reduced, on which voting does not take place for modifications. That is called charge expenditure. There are various things. Salaries of people, some loan repayments that the government has to do to international bodies. So if on such things, you don't modify it, you don't vote on it, you simply pass it. Why? So that these people, Supreme Court judges, High Court judges, the CAG, these important bodies are not made subject to the arm twisting at the hands of the government. That is why the salaries and conditions of service are not reduced to the disadvantage of certain officials to ensure independence. What has happened in this case is that the government has taken over the terms and conditions of service, plus the tenure now has been reduced to 3 years. What if there comes a situation wherein some IC becomes very active and keeps on forcing the PIOs into providing information to the people who have sought for the information? That may not be appreciated by the government. And in that case, the government can issue a notification and cut short the tenure of the concerned IC. So in this fashion, this provision can be misused. So this was the subject of a question asked in mains in 2020. So the question said, recent amendments to the Right to Information Act will have profound impact on the autonomy and independence of the Information Commission. Discuss. 10 marker, 150 word question. Now, this amendment has actually radically altered the character of Information Commission. Whereas in 2015, the Prime Minister of India, Narendra Modi, had said that Right to Information Act is a foundation of vibrant democracy. So when you make statements like these, this means only one thing. You have so much of respect and regard for the CIC, the Information Commission, but your actions showcase otherwise. Or else, why would you curb the powers? Why would you curb the independence and bring the body under your control? So the question said that these amendments will have a profound, a deep impact on the autonomy and the independence of ICs. Discuss on this. So what are the possible impacts? Understand the point here. We fully agree that the goal of RTI, now what is the goal of RTI? The goal of RTI is that the truth about arbitrary, autocratic and partisan functioning of the public bodies be exposed, be brought to light. But if you modify the rules in such a fashion which take away the independence, which bring the CIC, the ICs literally under the control of the government, how will this arbitrary, autocratic and partisan functioning of public bodies be exposed? First things first, center now has greater powers. Center now has crippled the neutrality of the Information Commission by ensuring that the Information Commission members are also some government servants, just like other employees of the government. And that is why, see the argument mentioned by the government. When asked, have you consulted the public before you brought this bill? Did you consult the people from the CIC or the SICs? Did you consult them? The government said, this is a matter between the employee and the employer, and there is no need to consult anybody else. Can you see the logic here? The government considers CIC, the SICs as employees of the government. They are not. They are independent people. If they are considered as mere employees of the government, how will they be able to force the government into providing information? Secondly, after the fact that their neutrality has been crippled, the second fact is that their status has also been diminished. And when you have lowered the authority of the concerned CIC, how will they be able to issue directives to senior bureaucrats? I mean, if you have practically the same powers and you are at the same level, it will take away the authority that the Information Commissions enjoy in issuing orders, forcing the bureaucrats into providing information. So, you have also diminished the status. Then, was any public consultation done? There was absolutely no public consultation whatsoever. Apart from it, the same CIC has forced the various public officials into providing information with respect to the non-performing assets, has forced the officials into providing information on demonetization. This and all these areas where the government has been forced into revealing information ensures the accountability of the government. But now you have taken away this power. This will eventually take away transparency, because now it will be easy for the bureaucrats to not really follow the orders of the CIC. Apart from this fact, the center deciding on the terms and conditions of service of even the state information commissions, does it not affect federalism? So eventually it affects the concept of cooperative federalism, and to sum it all up, as I said, it has radically altered the character of the information commissions and it will reduce the transparency in public dealing. These are some genuine challenges when it comes to the Right to Information Act 2019, the amendment passed to modify the terms and conditions of the SIC members and the CIC members. Okay. Now we have been discussing about the importance of RTI. We have been given with a lot of powers, forcing the government into providing information on all aspects.